Why are we held to this other standard? Well, again, we go back to that lack of a licensure requirement that says that these practitioners have to maintain practice in the English language for a simple, breakdown of it. So until we define that, this is the problem we're going to keep having. And one of the things that makes my case and my work unique is one of the conditions of my licensure is that fiduciary relationship. Real estate agents and brokers are required under our licensure to be specifically representing to our client. Nobody else. Dual agency is a whole different animal. That's not so much relevant here, but
well, I think
I have a licensure requirement that bar card members don't have. When you get to the part in the amicus brief when I say that,
there's a lack of accountability.
I'm not going to be forced to be, dictated to by a non-licensed practitioner, knowing that I have a license. So technically, when I wrote that brief, an amicus brief is written by licensed experts. Well, that's where the licensure is.
Yeah, and the licensure of any practitioner, a hairstylist, you become a part of that union, which is you're licensed through. Also, that's a whole nother area, but uniquely to the bar, there's no accountability there, and oftentimes in the lower courts, or even all of the courts, regular people are being they're not being given due process. Evidence is withheld and tampered with.
Those are the details. Yeah, those are the details that we're talking about that are what I've called associated victimization of this defective practice. Okay, so just to kind of let's put that into perspective. Using the hairdresser example, if the hairdresser follows a specific, pattern, way, what do you call that, method of how they achieve this specific look with their haircut or hairdo, whatever you want to call it, in order to get that look, they have to do these different processes to achieve that look. Now, the look is the thing that the customer looks for, which is the same thing what the people in these court cases are looking for. They're looking at they're looking at the hairdo. They know nothing about the process that it takes to make that thing what it is.
And we now know too that oftentimes the Ninth Circuit has confirmed that oftentimes transcripts are tampered with in these court cases, further convoluting the path to justice, clearing the path to justice. So,
and which is one of the reasons why another reason why the emoluments clause is so important, because records tampering is a felony. If you have proof that your record was tampered with, under the emoluments clause, whoever touched that file becomes a suspect and can be removed from position by authority of the emoluments clause. Okay?
Wow.
So that's not something that's ever been tested, but we're doing it now. And it's working. It's working.
This is awesome. This is really, I commend you, and I am so grateful that you're coming on the Porthole to Justice and you're sharing this with our listeners, because this is a huge, I really hope that it goes well, and I wish you all the luck in the world. Thank you so much you've hit the nail on the head with this brief, and you've done a very good job.
Well, I appreciate that. Thank you. And by the way, because it is the nature of what an amicus brief is, if you find different amicus briefs related that touch on the circumstances that are going on in your case, you can print those and file those as basically expert witness testimony. You are permitted to do that in court. So, obviously, I put it out there. You know, it's free. I don't want anything for it. Just, you know, I want you to use it in its proper context. And when you're talking about relationship to the defective practice of law. And when you start to look at it for what it is, you know, you start to see it really clearly. You know, who the little bugger is behind the curtain there. You know, the little short guy with 2 sticks in his hand trying to drive this monstrosity. And he's bouncing it all over the place. He's like driving like bumper cars. So, you know, they've literally lost control of it. So,
yeah,
you know, the thing we got to do is we got to rein it back in. And the way we do that, well, we've been doing fiduciary practitioner licenses now since, you know, more than a few years. So
well,
we have the model out there. We don't have to change anything. We have to change nothing about how government works. Everything remains the same. The only thing we're doing is we're defining the practice of law. That's all.
Well, this is awesome, and I thank you so much for sharing it with me.
I hope it helps. I really do, because it's been a very long project, and it's the more work I did on it, the more I realized it needed done. And
it's desperately,
along the way, as with any other project, but you know, we're to the end of it now, so that's the good news.
Well, that's awesome, and I've had the Porthole to Justice for 7 years, and I have written up letters for parents to document the fraud and the perjury on their court cases and submit it to for the last 4 years to government agencies like the bar, the FBI, and the DOJ, and till this date. I have not heard back from one parent having any correspondence or of any investigation into the corruption that's going on. So there's a real lack of accountability.
Well, and the reason for that is because, like I said, we only have that one option. Now, if you at the end of the amicus brief, I attached a cover letter and a 9-page letter to judicial members and independent contractors. Gave them a list of 7 things they cannot do, okay? But they're doing them anyway. So when I started doing the reading and research on that document, that directive from the Department of Justice, that was the thing that started what I did. So when I came together with John, and he did the homework on the lack of accountability through the different state Supreme Courts, and he compiled all the data in the appendix report. Okay, he did that end of it. I did the reading and the research into why are people not getting access to justice the way according to the directive and the office. So here's why. What the people need is more options. When you pick up the phone and you pick up the phone book and you flip the pages, there might be different names, but it's only one bar. Okay? Basically, you've got a Big Mac. Nothing else. Well, some people want a Big Mac. Some people want a Whopper. Some people want a beer and a pizza. You know, and keep going. And because those other options are not there, consequently, I also documented that in through the context of the case, there are no options. So what we have is one entity providing information to Congress, the court, and the president, and that information is in the conflict of interest of what the Constitution says. And it never occurred to anybody that this would become a problem.
You know, I'm thinking
we've got a problem.
Yeah, we have a problem. Houston, we have a problem.
I put that in my appeals brief, by the way, just so you know.
What I was thinking about, and maybe you might be more familiar with this than myself, but in the Constitution it says very clearly that there should be bar licensed and non-bar licensed voices. When there's I think it's like Williams versus the United States or something. And
okay, so we're talking about how they're trying to defend against requiring a license. Okay, here's what that case says. It basically says that everybody has the right to practice law, which is true. What we're talking about is the people that practice law for a business. Okay, that's the difference.
Mm-hmm.
So to represent yourself, you'll always have that right.
Mm-hmm.
When we're talking about businessing, representing other people for profit, you should do that. That needs to require a licensure, the same as any other practitioner.
But what I'm saying is that there should be a balance there of counsel that is licensed and not non-licensed, so that there is that option there for the people.
Right, and that's where the pro bono time comes in.
Mm-hmm.
We would obviously, under the condition of licensure, we require them to do so many hours of pro bono time per year
mm-hmm.
in whatever certification they want to certify in. So, one of the nice things about doing this the way we want to do it is it's also going to help the lawyers a lot. Because, for example, you've got, Joe Smith wants to go to law school to be a tax lawyer.
Mm-hmm.
He doesn't want to learn anything about maritime law. Say he's working in Colorado. Okay, well, Colorado's a landlocked state. There's really not that much need for maritime law in Colorado. So why am I studying this? Why is he paying for classes that he doesn't need?
And why do we have maritime law in our courts when we are on land and we should be having common law courts?
There you go. So that's why I said there's a whole lot of confusion and convolution going on, because you've got this entity trying to be all things to all people. Well, that's just never going to happen. Mm-hmm. You can't be all things to all people. That's why they're professionals who design rockets. That's why they're professionals who design cars and, fix them and repair them and build them. I mean, there's a reason that there are specialties. And the thing that we're asking them to do is to basically join the rest of the community and specialize in something.
Mm-hmm.
Nobody's saying you can't make money. As a matter of fact, we're going to show you how to do it and do it right.
Mm-hmm.
And as a licensed practitioner, I can tell you I've gotten pretty good at making money. I know how to do that. So, as far as that goes, you pick one thing and you do it right, you do it well, and the money comes in. That's how it works. So, this pulling this crap that they're pulling, it's just, literally trying to use the judiciary scale as a hammer is the way I quoted it in the brief. Well, it's clearly defined in the Constitution that that's the one thing they're not allowed to do. I mean, because that comes close to Parliament, which is the thing we left. So, when we started this country back in, when the Constitution was ratified in 1776.
Exactly.
So,
well, this is awesome. This is great news, and I hope you come back and you come on the show and you share with us how it went.
Absolutely. Well, like I said, as far as the case goes, the case was defaulted in my favor actually in May of last year. The only thing we're fighting about is why they're not following judicial procedure.
Mm-hmm.
Well, the reason they're not following judicial procedure is because there's no enforcement mechanism that's ever told them they had to. They've been told to just do this on your own.
Well, we actually have the appeals court, which they review to oversee and make sure that the lower courts are following policy and procedure. But that's not what's happening. It's basically, when you have 1% of cases being appealed, something's not right there.
Correct. And that's one of the things that, because that's where my case is now, is at the appellate level. And because it's at the appellate level, the only question on the table is because obviously nobody responded to the subject matter, the relevant subject matter in the case,